With so much content out there, how do you filter through all the noise and cut straight to the value? What has become very apparent is that the best way to learn is to surround yourself with those you aspire to be. But you can't just watch what they do. At some point, you have to turn it into an action. Knowledge isn't power. Applied knowledge is power. On this podcast, you will go on a journey as we speak to people who are making a difference in their industries, and people who, if we listen to closely and take action, can turn you into who you want to be. My name is Mark Sclair, and this is Your Turning Point. Bushra.
Hello, Mark.
Welcome to the show.
Thank you.
I want to start off because sometimes I can assume that people understand what we're doing this for, what we're here for today. So I want to kind of read your LinkedIn headline, actually, and we'll go from there. It says here, along with all the accolades you have as well, which I will mention later, litigator, arbitrator, and barrister, disputes and resolutions and employment specialisms, banking, mis-selling, regulations, and employment enforcement. Now, that would mean that I would say that you're a lawyer, yes?
Indeed.
Okay.
In a generic sense, I'm a lawyer.
Okay, perfect. Now, I know you from the UK, okay, but you're here in Dubai. So how are you able to be qualified in the UK and practice in the UAE? Can you let everyone know how that happens?
Yes. So let me just start by saying thank you for inviting me.
Yeah.
It's really good to see you.
Yeah.
As you said, Mark, we used to work together in the UK. I used to be a barrister, and Mark used to work in chambers with us, directing the barristers as a clerk. So it's very good to see you here. You spoke about being a lawyer. So lawyer is a generic term, which generally means that somebody is qualified to practice law and is specialised in practicing law. But in the UK, you have a distinction. You have solicitors and you have barristers. And the distinction is that the solicitors usually have daily conduct of the case, and barristers are instructed by solicitors to go to court and argue the case and provide specialist advice, expert advice on the case, and as well as settling pleadings, which is your case that you file in court. So that's the distinction in the UK. In jurisdictions like the US, that sort of distinction doesn't exist. And in the UAE, that distinction doesn't exist. So how is it that I can come here as a UK qualified barrister and practice law? So as you well know, and as your viewers probably know, the UAE is made up of a number of free zones. And one of the free zones is the Dubai International Financial Centre, that has its own infrastructure. It has its own court system, and the DIFC courts. And the DIFC courts are modelled on a common law system, and UK is a common law system.
Okay.
And so therefore those lawyers, and I'm going to use a generic term, that have practiced in a common law jurisdiction can come to the DIFC and practice law. So that's the first part of it. The second part of it is that you find many UK qualified and common law qualified lawyers also working onshore in the Dubai court system. Now, the Dubai court system is a civil law jurisdiction, but because lawyers have generally the same set of skills, namely problem solving, they can operate in these jurisdictions. So that's how, Mark, you find somebody like me practicing here. I primarily practice in the DIFC courts. I also practice international arbitration, which is a separate adjudication system than court proceedings. I'm also a mediator. I also sit as an arbitrator as well.
So everything you've mentioned there, it's so interesting because we talk about now with roles versus skills. And it's so interesting because so many of the skills which you have are transferable into other things. And I think this is an issue at the moment that's going on in the workplace, is that roles within jobs, they're not going to exist. That specific role is not going to exist. And now people need to look and be like, okay, what is my actual skill that I have within this role? And how can I apply it to other things? And it's great because it's a transferable skill. So you've been able to take your skills from the UK, come over here, there's a common practice, and you've been able to apply it and continue your career, which is what I love to talk to people about, because building a career, having that success within what you do, I think it's a wonderful thing. Having longevity, you see a lot of people jumping around these days, but being good at what you do, being recognized for that, I think it's a wonderful thing.
Indeed, and I agree. And I think as somebody who has trained in the law will have many transferable skills.
Yeah.
And so you often find that those that have read law at university or have even practiced law, they can then go on into different industries and apply those transferable skills. So, for instance, I mentioned problem solving, communication skills, the ability to absorb information, organize information. You need quite a lot of those soft skills, the people skills, the ability to read a room, to read your judge, to read your clients.
Yeah.
You need commercial skills, especially if you're practicing commercial law. And so all of those, I would say, is a package that one can use in different industries. And I'll give you sort of two ways in which I look at this. So I look at my past and the past sort of roles that I've undertaken, especially during holiday season. So, for instance, when I was 16, I was at a chocolate factory packing chocolates.
Yeah, nice.
So obviously, kind of that gives you communication skills. It gives you discipline and application. And sometimes the mundane tasks that give you the sort of set of skills that you can then apply. For instance, it's quite boring sometimes when you get a pack of papers and you've got to organize them. And I see junior lawyers sometimes complaining about that, but that's one of the most important skills because that allows you to know your case. It's a mundane task, but it's necessary. I've worked as a receptionist, communication skills. I've worked in a bed factory. As an admin person, I've worked in sales.
Yeah.
So these are all skills that I've been able to transfer and use in my core profession. Then you talk about transferable skills. And I think it's really important to sort of pause here and mention the way in which the world is progressing. We look at sort of AI, we look at tech, we look at how these digital tools are going to remove the need for people to do certain tasks. And if I look at it from a legal perspective, organizing papers, organizing calendars, all of those kind of low level tasks, very important tasks, but low level, will be replaced by digital tools. So then how do we as human beings stay on top of the profession or the career? We use those transferable skills, we hone them, and we become masters of AI and tech.
Yeah.
So I think, it's very important.
You've got to be able to use it. If a lawyer or a barrister or litigator or an arbitrator, whatever it is in that role, if you're not using AI, you'll get left behind. It's not that it's going to take your job, it's that it's going to take the job of the person that's not using it.
Yes, and you've got to hone your skills to master how to use AI in the most efficient way that adds value to your business but doesn't take over your role.
Yeah. I think as well, when you're saying like going through the papers and understanding the case, okay, you could give that work to the AI, to the robots, but still, when you're in court, you need to know what's going on in the actual file. So it's great that something's given you the cliff notes or the bullet points, but really it's in the detail where one little word or one little phrase that somebody's used could just unravel the whole case. So it's great that something's going to create a report for you, but you've still got to do the work.
I completely agree. I completely agree, Mark. And for me and my practice, I have to read everything. You know, even now, I've been at the bar for about 20 years. I still read all my papers. I read every word. And I think that's because we come from a tradition of being at the bar where you had to, because you were accountable, you were in front of the judge, you needed to know your case. And a case starts and finishes with the evidence, with knowing your facts, with knowing your papers. And so it's really important that you marshal the facts. And so none of this is without hard work. No. It's, you know, yes, you're absolutely right. You can get your AI to produce a chronology or, as you said, crib notes, but you have to do the hard work.
Yeah.
You have to do the hard work. And so when I go to court, I have to make sure that I know my papers inside out. And I'm afraid I'm still a bit of a dinosaur because I still need everything printed out. I still need to read it on paper. I still need to mark it up with my highlighters, with my Post-it notes. But yes, you have to. Yeah, you have to.
I think whatever works. You know, if you've got to print it off, if I'm doing a speech as an example, some people, they'll use their phone. I just can't do that. I need it printed out in front of me. Yeah. But I think just as you were talking about going over notes and everything, I think everybody has seen the show Suits,
yes,
and thinks that everyone's got a mic in their team who all of a sudden remembers a bit of work from some file that they were reading, runs back to the office, brings it back and closes the whole case.
Yeah.
It doesn't work like that, does it?
No, it doesn't. You know that, Mark. Yeah. You know it doesn't work like that. I mean, you were in chambers when probably Ronald Thwaites was there. Ronald Thwaites, great barrister with a great legacy and a great reputation, and he was head of chambers, and he was one of the best of his time, sort of amongst the kind of George Carmans of the world. And you know that it never happens like that. No. It's months and months of prep, months and months of knowing your papers, of sort of talking to your team, of taking a strategic approach. And that's kind of one of the most challenging but the most exciting things about litigation is nothing ever stays the same. With every day and every time a case moves forward, there is something new to consider and a new challenge and a new strategic approach depending on the case and where one is at. And so, no, it's nothing like Suits. No. It's a lot of hard work, a lot of sleepless nights, and a lot of strategic preparation.
Yeah. So I'm reminded from another movie, because one of the reasons why I wanted you on the show is that I'm fascinated by law. I wanted to be a lawyer. That's why I worked in the chambers. I'll say what I was. I was a clerk. I was an office junior. I came in at the bottom. And it's interesting because the barristers were amazing with me. And you were one of those. So I always appreciate that. Always kind to me, always polite, always asked. Yeah, I had to run around for you, but you did it. You asked me in a nice way. The ones that didn't treat me so well were the clerks. Because, and I get it, I completely understand it. I came in, I took their role, one went up one step, and they'd taken a load of crap from everybody else. So all of a sudden I thought, I'll treat him the same now as well. So I've got no problem with that. We'll have to start somewhere. And like you said, like you learn from those moments. I worked in my dad's surgery as a receptionist, communication skills, as an office junior. These things have put me in a good place for my future.
Indeed.
Yeah. But going back, there's a movie and it's called Law Abiding Citizen. And I love this movie, okay? And there's a phrase in there which I just want to talk about now because this is why it's so hard. It's not what you know, it's what you can prove.
Interesting, yes.
And I think a lot of people will say, well, this person did this wrong and this, well, do you have the evidence to show that? You know, so I think there's a lot of time where you might look at something and be, and please go into this a little bit, is that, okay, we haven't really got a case because there's no evidence here and we can't prove anything. But I know they did it 100%. We can't prove it. Does that come across?
Well, evidence is key.
Yeah.
Your facts, your evidence, what you can prove is the key to unlock any case. And it requires quite a forensic analysis of, first of all, what the legal issues are, what are the facts and the evidence that you need to prove those legal issues? How are you going to obtain that evidence? Where is it going to come from? And is this evidence, will the court give it sufficient weight for the court to find that it's going to prove your case? So, in a nutshell, evidence is key. Yes, evidence is everything. And just to kind of pause there and think about sort of how criminal cases are very different from civil cases, for instance, commercial cases, civil cases. Because you often find when somebody finds out that you're a barrister or finds out that the profession that you practice in, you know, the first question you always get asked is, well, how can you defend a criminal when you know that they might have done it? And that's not the question, and that's not the point. The point is that everyone, first of all, deserves representation, firstly. And secondly, what's the evidence? And can it be proved? And there are different standards in criminal proceedings to civil proceedings. So in criminal proceedings, it's beyond reasonable doubt. And in civil proceedings, it's on a balance of probability, which means you question the plausibility and whether or not one can say, or the judge can find, that it was more likely than not that something happened.
Well, I think as well, how was the evidence obtained? So someone would say to you, well, how can you defend this person? But how did they gather the evidence to build the case from that person? Did those people actually do it in a legal way?
So that goes to admissibility, the admissibility of evidence. And the UAE has quite stringent rules in place as to how evidence is obtained. So, for instance, it's a penal offence, it's a criminal offence to record somebody without their consent. So if one was to go into a meeting with their recording device on, and in the hope that they would obtain evidence, then that's a criminal offence, and that would not be admissible in court.
And they would get in trouble?
It's a criminal offence. They would, yes, of course, yes.
So somebody would come to you and go, oh, I've got them on recording. I've got, no. Did you tell the person you were recording
consent,
them?
yes.
Consent.
One would need consent, yes.
So people end up shooting themselves in the foot and actually end up in trouble themselves.
Yeah.
And I think this, in employment cases as well, I think this kind of tends to happen. They say, we've got this email trail, we've got this information, we've got that somebody sent us this message. I've even heard with like WhatsApp messaging, sometimes that can't even be used.
I mean, it depends the circumstances in which you obtain that evidence, kind of, and sort of the old rules of entrapment sort of come to mind. But I think if you are the recipient, let's say, of a WhatsApp message, then the sender has obviously sent it to you with consent. So that would be admissible. But if you are, like, as I said, if I am going into a meeting in the hope of obtaining evidence to prove my case without seeking the consent of the other party, then that's not admissible.
I think there's so many. I'm in this WhatsApp group, this HR networking WhatsApp group. Right. They share insights, and there's employment HR people there. And somebody will say, hey, we've got this this employee who's done this, this, and this. Can anyone advise? And a lot of the time, people are giving what they think is the actual right thing. And then somebody else will go, well, no, this is the updated law. And so they're giving advice and they're not really knowing. And I think this happens a lot in the UAE. There's so many grey areas not defined, and that's why it's so important to seek out legal people who can advise in the right way.
Because you've got to be qualified to give the advice.
This is it.
And I do hope this WhatsApp group doesn't name names, because there are data protection regimes as well, and confidentiality. They make that very clear. Because the minute you said that, sort of alarm bell started to ring. I agree. I mean, you need to go to a qualified person to receive advice. And not very many people know this, but you could also get yourself into trouble by giving wrong advice under, let's say, tortious obligations. I mean, obviously, there's a whole kind of law around it about whether or not there's a duty of care, whether or not there's a proximate relationship with that duty of care to arrive. And if you've breached that duty of care by giving wrong information and wrong advice, obviously it all depends on the circumstances. But I do think people have to be very careful before they give any advice. And so, for instance, I would always want a letter of engagement before I give advice. I don't want to give informal advice without knowing the facts of the case and the specific nuances of the case, because unless you are completely on top of the case, you can't really advise somebody definitively. High level advice, of course, in a general way, but be guarded not to give definitive advice when you don't know the facts.
So this moves me on nicely now to the next part, which is conflict resolution. And it's really important because I believe that things can be resolved before getting ridiculously escalated. Sometimes people in these, they go so far with it, when really things could have been done at the beginning and it could have been resolved very early on. So if you could just give some sort of information on how people can resolve those issues early on in disputes.
So I think disputes are just part of life.
Okay.
And there are different means of resolving different disputes in different contexts. When you come to a commercial matter, let's say, or an employment matter, and a dispute has arisen, my advice would be that the last thing you want to do is go to court.
Okay.
Because court means that positions become entrenched quite quickly. And the costs of going to court are colossal.
Yeah.
You couple that with the emotional stress as well that it has on people, even if they are part of an entity, is quite significant. And I think people underestimate the difficulties associated with going to court. As I've mentioned, the expense, the time, the mental strain, all has an impact. And so I would primarily say if you can avoid going to court, you should. Now, that's easier said than done because disputes by their very nature have arisen because people, two parties or three parties, but a group of people have polarized opinions on what they think a resolution should look like.
Yeah.
Which leads me on to the various mechanisms available for disputes to be resolved. And the first mechanism is mediation.
Okay.
There are a number of mediation centres and different rules by which a mediation can occur. And a mediation is a formalised approach where the parties can instruct a mediator, either pursuant to certain rules or on an ad hoc basis where rules are agreed, almost rules of engagement are agreed. And the person appointed as a mediator acts as go-between to try and find a middle ground.
Yeah.
And a good mediator will speak to both parties and try and unpick what the issues are.
Yeah.
And try and see if a middle ground can be reached. And there's quite a lot of psychological or psychology involved here. And so I think mediation is a good source of dispute resolution, but the parties they've got to want to resolve the dispute for mediation to work. The alternative to going to court, another alternative to going to court is arbitration. Arbitration is a consensual process where both parties have agreed by a contract, which is part of the overall contract. And just very quickly, a contract is where is a document that enshrines both parties' rights and obligations. And within that document, there'll be an agreement to say, if there is a dispute, then we will resolve our dispute by arbitration. They agree rules, language, the law that's going to be
Okay.
applied to the dispute, the number of arbitrators that are going to adjudicate the dispute. So it's a set of rules by which both parties adjudicate their dispute, and it's confidential, which is I think important to parties, because one of the aspects of a dispute is the effect reputationally on the parties. And also, there are other considerations as to why you wouldn't want to go to court or arbitration, or you might want to keep it confidential. That is because you may want to preserve the relationship. You may have a familial relationship if it's a family dispute. You may have a commercial relationship. You may have a dispute arising out of one contract, but there are lots of other contracts where you are both parties to that contract. You want to preserve that relationship. So again, another reason why one ought not to go to court.
Yeah.
And then, of course, you have court proceedings. And there are many reasons why parties want to go to court. They have their own agendas sometimes. There's an ego issue. There's a floodgate issue. There's a deterrent issue. There's a let's stamp this down now by showing how strong we are type issue. There's a number of strategic reasons why parties may want to go to court, where costs may not be an issue. But I think, generally speaking, I would advise informally,
there we go.
generally,
Yeah.
all caveats in place,
Yeah.
that if you can avoid going to court, then do.
Yeah. So when we look at mediation, you don't need to be legally qualified or be a lawyer. And I'm saying this because in life in general, to actually be that person that can sit in the middle between two people and remove the emotions from it,
Yes.
that is a great skill to have.
Yes.
And when you can learn how to ask questions to that person without frustrating them, and again, it's the tone you use and how you deliver it. These are all things that apply in life, I think, and that's where it's not what you say, but how you say it. So somebody could get really offended by how you've said something to them, and then somebody says the same thing, but in a slightly different way, and they're just not offended. Yeah. So when it comes to the mediation side of it, I just think that's a great skill to have.
Yeah.
And as a leader, as a manager, anyone within a business, whether in HR, whatever part of the business it is, if you can be that person that can sit in the middle and hear people out, it's going to be something that can make you really successful and have people that want to be around you and want to have them being heard and listened to. And again, that's something which is, for me, really important, because people, a lot of the time, they don't feel heard, appreciated, or understood. So a lot of the time, they just want to have somebody go, "Oh, you've actually understood what I've said."
Yeah.
Yeah.
And Mark, you have quite astutely, quite wonderfully hit the nail on the head, because in life disputes arise, and you will know a friend who has sat between two warring friends. I mean, not quite warring, but two friends who may have fallen out.
Yeah.
And you're sort of in the middle of it, and you are banging their heads together to try and resolve whatever kind of dispute it is. And so I think you're right. Sometimes people just want to be heard.
Yeah.
And to be, therefore, coming back to your question about whether or not you need to be a lawyer, you don't necessarily need to be a lawyer, but you need to have the skill set of being able to understand how to navigate around what people require, and how what they consider is a resolution of their dispute.
Yeah.
And so, I know some very good mediators who don't come from a legal background, but they've got the skill set, either because they've kind of done courses, or they've seen that they can be a mediator because of natural kind of talent and skills. And they've then gone on to kind of undertake courses that have given them that formal qualification, if you like, to become a mediator.
Yeah.
But you're absolutely right. To be a good mediator, listening is very important. Hearing out what the parties have to say about their case is extremely important. And sometimes it's just those soft skills that are needed to be able to then work out what is a solution here.
Yeah.
And you're never going to find a solution that both parties are going to be completely happy with. But at least they've had the opportunity to air out what their grievance is and what's going to be required to close out that grievance.
Yeah, and I think a lot of the time, maybe at the end of this, somebody's response on the other side is, I never knew you felt that way. You know, like, oh, is that really how you felt? Now I know. Now I've had somebody come in that's actually kind of made me realize this. We can resolve this. Because it was two people talking, but nobody was listening. And they were just waiting for the other person to speak or other person to finish, and they could speak and just give their information. And that's where active listening comes in. You're actually hearing what they're saying, taking it in. And that's why when I'm with clients, I let them process the question. I let them process what I'm trying to get across. Because if I just keep on talking, they don't have time to process it. And this is a journey that I went on a number of years ago when I was working at the chambers. And I decided, right, I'm going to go back to school and I'm going to study law, and I'm going to show them that I can do this, because I wanted to be a lawyer. Okay. I never hide away from that. But as I was working or studying to be back at college, I got offered a part-time job at a property company. And I was working there 3 times a day. I was doing 3 shifts. And I was meant to be going to college. And it got to the point where it was like, well, you're not coming into college, you're just working now. And I was like, no, I want to be a lawyer. And I felt the social recognition for that as well. I felt, to be a lawyer, you're held in high regard. I wanted that. And I'm at this position where I was like, well, no, I'm just going to be a salesperson now. That's what I'm going into. And I wasn't proud. I wasn't proud to say I was a salesperson. But then I realized that there's so many things which you can do as a salesperson or sales professional, is what I like to call myself now, that correlates with practicing law and being a lawyer, like solving problems, conflict resolutions, standing up for somebody, protecting somebody, getting people what they want. And once I knew that if I applied myself every day to develop, I could hold myself up high in a high regard and not care. When somebody says, oh, you're a salesperson, I say, yeah, I am. I'm proud of it, because it makes the world go round.
Absolutely. Yeah.
Yeah. That was my little moment there. Sorry. Yeah. Yeah.
But I think you've touched on some really important points, which are that there are no limitations, I think, as long as you persevere, as long as you show grit and resilience. I think, and it all requires hard work. Of course it does. But you apply yourself, then I think you can achieve whatever goal you want to achieve. And then I think the other point that you touched upon, which I think is really important, is listening. We were talking about skills, and we're sort of coming back to where we started.
Yeah.
Listening is one of the most important skills one can have in life, but particularly as somebody who is going to be a problem solver. And that's what we are. We offer solutions.
Yeah.
You offer solutions in a different way. I think lawyers, and I'm going to use a generic term, offer solutions in different ways, and we're all problem solvers. But in order to solve the problem, listening is a key skill.
Yeah. Well, I used to say that my job is to be a problem solver. But then I went on this journey of like really understanding that. And the thing is, somebody comes to you and they say, we've got this problem. And then you end up speaking to them and listening to them, and actually ends up being something completely different. So I don't say I'm a problem solver, I say I'm a problem finder. And that is through sitting on discovery, analysis, sitting with that person, having a conversation, and actually it ends up being something completely different. But again, you can't tell somebody, well, no, that's not your problem, this is your problem.
Yes.
You have to be able to deliver it in such a way where they don't feel, they might have a big ego and they don't want to be seen as doing something wrong. So you have to make them feel that, oh, they came to that decision themselves as well.
Yeah, no, absolutely.
Yeah. Within your title as well here, it says mis-selling. Yeah. And I love this because I think salespeople, they think they can say and do what they want, and that's okay. It's still fine, no problem. But I like to see that there is people can get in trouble for this, for mis-selling. So I think, what are some warnings which you would give to people in regards to that, really?
So mis-selling is when, let's say, a product, usually in sort of the financial services sector, the insurance sector, the consumer sector, is missold. And so, which means that you have sold a product to a consumer or a user on a false premise. You have made either a false representation or a negligent representation or a reckless representation, which doesn't actually accord with the product that you're selling. And there are consequences to that.
Good.
There are legal consequences that I can talk of. So, for instance, if one was to take a financial product and that's been sold on a false premise. Let me give you an example. There's a financial structural product on the market, and you tell your investor that if you invest in this product, then your capital is guaranteed, so your money is guaranteed. You're always going to get that back, and your yield will be, let's say, you will make 10% yield on this product.
Yeah.
But actually, that's not correct, because there are risks attached to this investment product.
Yeah.
Your capital isn't guaranteed, or you may not make 10% because it may be aligned with the market, and the market could be volatile, and so you may even lose money on your investment. So you haven't explained the risks of investing in this product. That is mis-selling. Again, keeping with a financial product, there are regulatory breaches there because these products are regulated.
Can I just jump in a second there? So somebody would say, but we sent them the terms and conditions. They should have read the terms and conditions. It's not our responsibility to tell them. Do they have is that a point? Because people sign off T's and C's. They just go, oh, I agree, terms and conditions, done.
Yes.
And you never know what you're signing for, really.
I mean, so let's start from the beginning here.
Okay.
You've got the regulatory law.
Yeah.
You have the DFSA, which is the Dubai Financial Services Authority, which supervises everything to do with financial services. And the DFSA has a rule book. Within that rule book, there are general rules and conduct of business rules. And other rules as well, depending on the sort of type of product that you're selling and the type of financial service that you're providing, which provide a framework and a set of rules pursuant to which let's say a seller or arranger of financial products has to follow. So that's the starting point.
Okay.
And then within that, and so those are your regulatory obligations that you've got to comply with as a seller or an arranger or a dealer in financial products. And of course, this is all very generalist, but it's kind of an overview.
Informal.
Informal. It's an overview.
Yeah.
Then you have your contractual obligations, and that's what you've mentioned, sort of the T's and C's.
Yeah.
And the contracts usually are quite tight, wherein there are exclusions of liability and exemptions and indemnities and all of that sort of thing. So, for instance, you're an investor. I am a relationship manager of a bank. I am selling a financial product. I come to you, and there are those regulations that I've got to comply with. So, for instance, I've got to assess whether or not the financial product is suitable for you, whether or not you are a sophisticated investor, to what and that informs to what extent do you understand the risks, to what extent do I need to disclose the risks to you or inform you about the risks. And then I give you this kind of document, terms and the contractual document, and there is an expectation that you will read that.
Yeah.
There is an expectation that you will sign it on the basis that you've read it.
Yeah.
Now, if, let's say, the seller hasn't complied with the rules and regulations, then the seller will be in trouble, and you'll have to prove, for instance, that there was no risk assessment, there was no suitability check, there was no assessment of your knowledge as an investor. So that's on the seller. But then if you have signed a document which excludes liability, for instance, then that's on you, I'm afraid.
Yeah.
Unless you can prove you didn't read the document, you didn't understand the document wasn't presented to you in its entirety. When I say that, there are cases wherein investors have just simply been presented with a contract and told, sign here, the last page. Nobody's gone through the contract with them. Nobody's explained the contract to them. So, there are kind of nuances to that question that you've posed.
Yeah, no. And again, it's not what you know, it's what you can prove as well.
Yes.
Yeah. So that's what it comes down to at the end. I read the document. Okay, can you prove you read it? I didn't read the document. Can you prove you didn't read it?
Yeah.
Yeah. And
so as I said, in that kind of mis-selling type framework, you've got your regulatory offences. Have you followed the regulatory framework that governs your particular industry? Then you've got your contractual obligations, and generally speaking, if you have signed kind of a contract, it's generally speaking, if you can't prove that you didn't understand it, it wasn't explained to you, then generally speaking, those contractual terms will apply, and it's very difficult to then kind of rely on sort of the contract. But then there are other legal avenues that you can pursue. As I've already said, misrepresentation. Have you made a representation which was false, which was negligent, which was reckless, that induced the other party into entering into that particular contract? So you've got those claims. You've then got tortious liability as well. I've already sort of mentioned that.
okay.
So the fact that you have a relationship, if it's a proximate relationship, which gives rise to a duty of care, so the seller has a relationship with the investor or the buyer, that creates a duty of care on the seller to explain, for instance, the risks, the consequences. Have they breached that duty by not explaining it to the investor, and has it caused loss? So there's a kind of tortious liability and a tortious framework within that. So I think I've covered off all the kind of avenues: regulatory breach, contractual breach, negligence, and misrepresentation.
Nice. So I think as well with this.
You've got to have causation. Did it cause loss?
Therefore,
what's the loss? So these are kind of general points that one would need to consider.
Yeah. But I think as well, if we look at a business and somebody says, oh, I didn't sign this, or you never told me about this, a lot of the time it's easier just to go, okay, we agree, rather than somebody putting on a Google review or a Trustpilot thing, and then the company name gets tarnished. Some people just prefer to resolve it and go, okay, you're correct, rather than drag it through that way. And because once that news is out there, I think that's the threat that comes with companies. They're like, somebody will post a bad thing about that business, and then
so reputation management.
Yeah.
Yes.
Yeah.
So well, of course, these are all considerations and factors businesses need to consider. How is it going to affect the brand? How is it going to affect the reputation? What can we do to mitigate the risk? And therefore, that will also then play into whether or not there is appetite to resolve the dispute.
Yeah. Well, I think if you've been watching and not listening, you see that I like to put things up on the shelves here. So we have Rocky, we have a painting by my niece Harriet, we've got a scene in The Godfather. Very rarely you've got Robert De Niro and Al Pacino together. But next to that, there has been a box here for the last 1 hour, and it has our guest's name on the box. Now, if we look within the UK, as you said, you've got solicitors and you've got barristers.
Yes.
And one of the big things with a barrister is something that they put onto their head. And I'm really pleased that you brought this in today, because I think this is the one thing when we think of UK law and we watch TV, this is what I think in a black cloak and something on their heads. So if you'd like to, can the people see this? Is that okay?
Yes, of course.
Yeah.
So this is my wig case.
The wig case, okay.
Which I bought with my gown
Yes.
and my bands.
Yeah.
When I was called to the bar. So as a barrister, you go to bar school. You have to dine at your inn. There are 4 inns in England: Gray's, Middle Temple, Inner, and Lincoln's.
Yeah.
And so you have to dine in your inn. And once you finish your bar course, as it was called then, you get called to the bar, so to speak. So there's a ceremony, and following that, I bought my wig and my gown and my bands, and I have my wig here with me.
Amazing.
Yeah. So there you go. This is They don't wear it anymore. I mean, historically, they were worn because obviously the courtroom setting is an august setting. It's a formal setting.
Okay.
And it was to give anonymity to barristers who were...
Meaning?
Well, anonymity in the sense that everyone sort of, let's say in a criminal trial, it kind of anonymizes by way of a uniform the barristers that are representing their clients.
You could clearly see who that was as a barrister. With that, it defined, like, you didn't have to look around and think who was the barrister. That would show,
Yes, that's your legal representative.
Yeah.
Yeah.
Amazing. Would you mind putting it on? Or do you want me to put it on? I don't mind. Is another person allowed to wear?
Well, it might not fit you. Let me.
Okay, go on.
Okay.
Go on.
So I've got my gown here as well, but I didn't bring it with me.
Okay. I love it. Amazing.
Would you like to try it on?
I'd love to. Yeah, it might be a little bit small, but I'd love to. This is something which I was trying to be, but never got to it. So I'm pleased I'm allowed to wear it. Let's see. Don't want to mess up my hair, but
well, there you go.
Yeah, there we go. It had a nice ring to it, and that's what's interesting now as well. It's now a KC, not a QC. King's Counsel.
Yes.
Yeah, I love
that. So if you have the initials KC or QC after your name, it means that you have made silk. So you are an expert in the law.
I think that's a great high note to finish on there. Bushra, I'd like to thank you so much for being on the show. Where can people reach out to you? How can people get in contact with you?
So I am a partner in a law firm here, KBH Limited. I'm in the DIFC. Look me up. I'm quite known on the website. So perfect. They can reach out to me there. And I think from my perspective, thank you for inviting me. I know we kind of didn't want to make it too much about law, more about sort of how lawyers fit in on a kind of in a commercial world sense. So I hope I've delivered on that.
Yeah, I mean, I think we could speak about this for hours. 1 hour definitely wasn't enough. Maybe we'll have to do this again.
I'd love
I think
to.
as well, dive a bit deeper into it. But
I'd love to.
For now, thank you so much for being on the show. And I will put your information on the video as well, so they can reach out to you for your services. Thank you, Bushra.
Thank you, Mark.
Thanks for listening and watching, everybody. As I mentioned before, you could have been anywhere else, but you've been here with me along this journey, and I appreciate that. Now, if you like this, please give it a like and a share and a follow. I'm trying to spread this across the community, and that simple press of a button is going to be able to do that. So let's help the community out here by giving it a like, share, and a follow. Thank you, everyone, and I'll see you next week.